Hi, everyone who's in the process of joining the webinar now. Welcome to the first webinar presented by the Australian chapter of the International Institute of Communications for 2022. My name is Angela Flannery and I will be moderating this session today. I would like to start with an acknowledgement of the traditional custodians of the various lands throughout Australia where participants in this webinar are located today. I pay my respects to elders past, present and emerging and recognise and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of Australia. The topic of this webinar is the interconnecting issues of online defamation and regulation of social media content raised by the Social Media Anti-Trolling Bill, which the government introduced to Parliament in February of this year. Following introduction, that bill was immediately sent to the Senate Legal and Constitutional Affairs Legislation Committee for public consultation. The committee is due to report on the bill by the end of next week, which leaves open the possibility that the bill may be passed before the federal election, which we're all anticipating will be in May this year. Notwithstanding the name, the bill is more concerned with defamation than with trolling. It responds to the Voller decision of the High Court in 2021, which found that individuals and organisations with social media pages may be liable in defamation for comments posted on their pages on the basis that those page owners are the publishers of those comments. The bill overturns that decision by providing that this will not be the case, but also seeks to put in place a regime to facilitate social media platforms assisting in unmasking individuals who may seek to make defamatory comments on an anonymous basis through such posts. As you no doubt know, the bill has been controversial, as evidenced not only by media commentary, but also by the many different submissions that have been made to the Senate committee and the recent public hearings of that committee. The format of this webinar is that we will start with a pre-recorded speech by Senator the Honourable Amanda Stoker, who is the Assistant Minister for the Attorney General, the Assistant Minister for Industrial Relations and the Assistant Minister for Women. We will then have a panel discussion with the panellists that you can see on the screen. The first panellist, Professor Catherine Gelber of the University of Queensland, is head of the School of Political Science and International Studies, as well as Professor of Politics and Public Policy at the university. Her research is in the fields of freedom of speech and the regulation of public discourse. Next, we have Barrister Richard Potter, Senior Counsel. Richard specialises in all aspects of media law, including defamation. We are particularly pleased to have Richard with us today, as he was one of the senior counsel in the Voller case that has been the catalyst for the bill. And our final panel member is Henry Turnbull, who is the head of public policy for Snap Inc. in the Asia Pacific region. As I'm sure I do not need to tell you, Snap is the owner of the Snapchat app, which is a messaging app that allows users to send images, videos, and instant messages that are available for a short period of time. Therefore, Snap and Henry have a keen interest in Australia's regulation of all things digital platforms related to social media. We are very grateful to all these panel members for joining us today, as each of them will have very valuable and unique perspectives into the issues that have been raised by the bill. I'll now move to start the speech by Senator Stoker.
Hello and thank you to the International Institute of Communications for inviting me to speak with you about anonymity online and the Social Media Anti-Trolling Bill of 2022, which is currently before the Australian Parliament. Within my lifetime, the internet has grown from a curiosity to one of the most transformative technological innovations of our time. The ability to connect with people all across the world and to have near infinite access to information in our pockets is not only something we now take for granted, it's something many of us would struggle to live without. But as Australians spend more time online, they are also exposed to greater online harms, including exposure to emotional risks, mental health and financial harms caused by online trolls, many of whom hide behind the shield of anonymity. The Australian Government is committed to ensuring the safety of all Australian people online. This is why we created the eSafety Commissioner. It's the world's first government agency solely dedicated to tracking online abuse and keeping citizens safer online. It's been remarkably successful and appreciated. We've also been sure to balance the need to tackle online harms with the preservation of a free and open internet. The Social Media Anti-Trolling Bill is no different. The bill is a targeted reform that addresses two important issues. It ensures that our defamation law is fit for purpose in the digital age and empowers Australians to respond appropriately to defamatory attacks by anonymous social media trolls. Much of today's online world relies on user-generated content. It's been made possible by a US law that ensures online platforms are not liable for things that are posted by third parties. That comes from Section 230 of the Communication Decency Act. That's from the US, and it states that no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. This has been described as the 26 words that created the internet, because it allowed for an explosion in online platforms, all of which rely on user-generated content. These include everything from social media platforms like Facebook, Instagram and Twitter, video sites like YouTube, review sites like Yelp and even Wikipedia. Now, Section 230 isn't an Australian law, and we've never passed similar legislation here, but until recently, the legal status quo effectively recognised a similar distinction between online platforms that provide a forum for user-generated content as against traditional content publishers that directly commission, curate and publish content. This was until the High Court's decision in Fairfax Media Publications and Voller. In that case, a majority of the court determined that the appellant media companies were publishers of defamatory comments that had been made by third parties on their Facebook pages. This decision not only opens up online platforms to legal liability for content posted on their sites, it also means Australians who maintain a social media page could be liable for defamatory material posted by someone else, even if they don't know about the material. This is the first problem that we are endeavouring to address with the Social Media Anti-Trolling Bill. The second problem is the harmful impact of defamatory material that is posted on social media, often anonymously. The ability to disseminate material very rapidly and for posts to spread virally is an integral part of social media. Where a post is defamatory, the potential for accusations to spread extremely widely in a way that cannot easily be contained can amplify the harm that is caused. It's clear that where Australians find themselves being targeted by defamatory social media posts, it can at present be difficult to respond. It's also clear that different types of responses can be appropriate depending on the nature of the defamatory material and the circumstances of the person being defamed. Some people will take no action. Some will report the attacks to the platform. Some will contact the eSafety Commissioner or another regulator. But those who have suffered the most extreme attacks on reputation, or who are bearing the significant emotional, mental health and financial costs of being so attacked, may wish to consider options to vindicate their reputation, including legal proceedings. For those Australians who may be considering legal proceedings, the Social Media Anti-Trolling Bill provides powerful tools to help respond appropriately to defamatory attacks on reputation on social media. The first key feature in the bill is a clarification of the current law around publication of defamatory material on social media. The bill makes it clear that Australians who operate or maintain a page on social media, called page owners in the bill, are not publishers of defamatory material posted on their page by a third party. This modifies the outcome of the Voller decision, and in effect, it protects Australian page owners for potential defamation liability for comments that are made by others, regardless of where in the world the material may have been posted. The bill also clarifies that social media providers are publishers of such defamatory material. But it provides a conditional defence against this liability. The second key feature of the bill is that it empowers Australians who are the subject of defamatory material posted on social media to be able to respond appropriately and in their own interests. In doing so, it seeks to centre a dispute between the aggrieved person and the poster of the defamatory material. This is consistent with the principle that the person who posts defamatory material ought to be the person who is held to account for those posts. However, where material is posted anonymously, it can be very difficult to pursue the poster, whether to seek informal resolution of the dispute or to commence legal proceedings. To address this issue, the bill creates mechanisms that allow a complainant to ascertain whether material was posted in Australia, and if so, to obtain the poster's contact details. This can be done through a complaint scheme administered by a social media service provider, or through a new form of court order called an End User Information Disclosure Order. If material is posted in Australia, the complaint scheme will allow the complainant to obtain the poster's contact details with consent. Alternatively, a disclosure order may require a social media service provider to disclose those contact details to the complainant. The bill uses the term relevant contact details, which includes a poster's name, email address, phone number, and such other details as are specified in legislative rules. These details are intended to put the complainant in a position to obtain an order for substituted service to commence defamation proceedings if necessary. Importantly, the bill provides incentives for social media companies to help victims identify these posters. This includes providing a conditional defence from defamation liability, which can be accessed where a social media service provider adopts and complies with the complaints and disclosure order mechanisms. Providers who do disclose that information with consent or pursuant to a court order will thus be protected from defamation liability, so important to the viability of their operations. In this way, the bill centres the dispute between the aggrieved person and the individual who posts. As is no doubt apparent, those aspects of the bill which seek to disclose the contact details of the posters of anonymous material raise questions about anonymity. We recognise that many Australians have legitimate reasons to be anonymous on social media or to use a pseudonym. For example, anonymity can enable marginalised groups in the community to use the internet without fear for their safety. It's often used by people as a means of protecting the identity of their children. The bill does not prevent social media users from operating anonymously or under a pseudonym. It does not require social media users to make their real name visible online. But this does not mean that social media users should be able to abuse anonymity to defame or harm others. Available research into online harms, which can overlap significantly with defamation, is illustrative of the particular problems caused when anonymity is abused to inflict online harm. For example, the UK Law Commission has noted that offenders may act in a way that they wouldn't do offline, in the belief that they can get away with it because they're anonymous. In the same report, the Law Commission also noted that perceived anonymity can contribute to online harms experienced by the victims. Not knowing who is perpetrating online abuse can impact real-world lives. In extreme examples where a person is targeted by a group of anonymous abusers, it can feel like it could be anyone on the street, to quote that report. Research into adults' negative online experiences published by the E-Safety Commissioner in August 2020 found that of those who had negative online experiences, 29% reported that they did not know who was responsible for that negative experience. And most fundamentally, anonymity is a significant barrier to taking appropriate action in response when faced with defamatory statements. You cannot commence legal proceedings or even ask for remedial action if you don't know the identity of the poster. These competing considerations, the real-world benefits of anonymity and the potential for anonymity to be abused, must clearly be balanced. The Social Media Anti-Trolling Bill strikes that balance. It establishes pathways to obtain a poster's contact details when potentially defamatory material has been posted on social media. It also includes important safeguards to limit it when anonymity is removed. First, the disclosure mechanisms are only enlivened where there is reason to believe that there is a legitimate defamation claim. The bill therefore only enables the disclosure of personal information where potentially defamatory material has already been posted on social media, and not in any other circumstances. Second, relevant contact details can only be disclosed with the poster's consent or pursuant to a court order. This ensures contact details are only disclosed in appropriate circumstances. The consent requirement is an important safeguard to protect both anonymity and privacy. It will ensure that social media service providers will not disclose private information freely, and that they do not need to make complex assessments about the merits of individual defamation claims. Disclosure without consent will only be possible with independent judicial oversight. Among other things, the court will consider whether there is a legitimate defamation claim when deciding whether or not to grant an order. A court, not a social media service, is best placed to make that assessment. The bill also makes clear that if there is information before the court suggesting that disclosure would create a risk to the poster's safety, a disclosure order should not be made. Taken together, these measures strike a careful, nuanced balance between the interest in allowing aggrieved Australians to commence defamation proceedings in relation to anonymous online posts and the interests in preserving the legitimate uses of anonymity online. While the Social Media Anti-Trolling Bill focuses on defamatory trolling on social media, it complements other measures on the Commonwealth statute books, like, for instance, the Online Safety Act and the Criminal Code, which address other forms of trolling and other online harms. Together, these measures form part of the Australian Government's sincere commitment to supporting the safety of Australians online. This is a vital response to a world that is changing and a world that is more online than ever before. Ensuring that Australians are protected in this space and in this evolving context sits at the very heart of this work, and I know it will continue to drive it forward. Thank you very much for your contribution to this important industry.
So it's a shame that we don't have the Senator in the room to also participate in the panel discussion, because I'm sure quite a few of you would have questions arising from that presentation. But we do have a team of experts to discuss the bill, and if you do want to raise any questions for consideration by the panelists after their presentations, please use either the chat function or the Q&A function. So we're going to start the panel session by turning to Richard Potter for his views.
Thank you. First of all, I apologise if I sound a little stultified, because to get the total material in within 10 minutes, I'm having to pretty much script it, rather like Senator Stoker. I've been asked to initially provide a summary of the central provisions of the bill, but Senator Stoker has provided that to a great extent, so I won't repeat her description. The four main areas are as follows. The bill gives immunity to social media administrators, such as Facebook page administrators, as well as everyday community Facebook pages. Secondly, the bill deems social media services such as Facebook, etc., to be publishers who will not have the benefit of any innocent dissemination defence. Thirdly, the only defence for such social media services will be this so-called safe harbour defence stipulated in the bill, with conditions which include disclosing to the complainant if the commentator is within Australia or overseas, requesting the commentator if the details can be handed to the complainant, and opening an agent's office in Australia, which obviously is a contentious issue. If the complainant cannot get the contact information, they can seek a disclosure order from the court. They're the central provisions. First of all, I'll address the immunity to social media page administrators. And for the first time that I've seen, there was mention of Section 230 of the US Communications Decency Act. That's not been in any material or on the AG's website. That section provides a blanket immunity for all providers and users of an interactive computer services for publication by another information provider. It is not restricted to social media, but any information service or system which enables access by multiple users, including libraries and education institutions. And Senator Stoker said, in effect, Section 230 is the inspiration here, as it gives immunity for user-generated content to the operator of an interactive computer services. Further, until recently, I understand that she said, the legal status quo effectively recognized a similar distinction between online platforms as traditional content publishers. And Senator Stoker went on to say that this state of affairs was regarded to be the law in Australia before Fairfax and Voller. As I've just said, Section 230 provides no distinction between online platforms and traditional internet content providers. Secondly, no distinction was ever raised or argued in Voller, either at first instance, in the Court of Appeal, or in the High Court. The law of publication in this country has been the same for over 100 years. Anyone who's connected with the act of publication is a publisher. And those who do not know the content have the benefit of the defense of innocent dissemination, which is essentially a negligence or no negligence defense. The appeal in Voller was only concerned with the issue of publication, as it was essentially a strikeout before the filing of any defense, which would include innocent dissemination on the basis of no publication. And the only real argument put by the Facebook administrators was that a legal text dating back to 1891, known as Folcard, used the word intention. And therefore, their argument was that the law of publication should be that there's no liability unless the publisher actually knew of the third-party content and therefore intended it. And at paragraph 22 of the joint judgment, their honours said, the appellant's contentions are not supported by authority and cannot be accepted. And the two dissenting judges did not dissent on the issue of publication, but considered that the law should change to reflect a position where there needs to be more than a remote connection between the post and the comment. In other words, they were saying no publication where there was no negligence on the part of the publisher, which is the essence of the innocent dissemination defense, which could yet have been pleaded and heard through a subsequent defense after the appeal had been concluded. But in fact, Voller has now settled without trial, and so that issue will not now be determined, at least in that case. The bill, therefore, seems to me to be a reaction to an issue which, when looked at closely, is no substantial issue at all in relation to the law of publication. The law of publication does not need to constantly change to meet changing technology. It is sufficiently flexible to be balanced by the defense of innocent dissemination, in my view. And of course, this would be the very first Commonwealth statute on defamation. And the irony is that it provides immunity for social media administrators, but they would still be liable under existing defamation law for third-party users on their own public interactive websites. So the incoherence between different laws in state and federal law on the same subject is obvious, and that doesn't happen in the US. As to community social media pages such as Facebook pages, again, they are unaffected in my view, as they are innocent disseminators until made aware of defamatory content. And they can then decide whether to keep it up or down, as the case may be, once they've been notified. So there does not need to be a blanket immunity to protect such users. The second element in this bill is no innocent dissemination defense for social media services. Whilst the social media page administrator is immune in respect of third-party comments, the social media service, such as Facebook, is not immune, and is in fact deemed to be a publisher without the benefit of any innocent dissemination defense under common law or statute. Now, that's generated a great deal of dissatisfaction amongst platform operators who have long been comforted by the existence of this defense, both here and across the whole common law world. Looking at the various submissions, YouTube said 500 hours of material is uploaded every single minute. So the defense is very important to it. moving on to the innocent dissemination defence is replaced by the safe harbour. The new Part 2 defence involves a convoluted complaint scheme under Section 16, where the offending commentator must be notified within 72 hours. The social media service must ask if the commentator consents to disclosure of his or her contact details. And one asks rhetorically, why would any anonymous commentator ever consent to that? And these provisions also encourage the collection of personal data with impunity, which clearly creates another tension with privacy considerations. There is also an escape clause if the social media provider reasonably believes the complaint is not genuine, that doesn't have to do anything. There's no mention of any test for reasonable belief in what could constitute such a broad discretion, which will no doubt create more litigation. Also, there is a compulsion for social media services to have an Australian entity or agent in Australia. There's no requirement that the agent is liable for publication by the social media provider. And in the submissions that I read, the social media providers say there's a potential for breach of the free trade agreement between the two countries, which says neither party may require a representative office in its territory. So there's some tension there too. Now, the court orders, known as the end user information disclosure orders, if it all fails, then a disgruntled person who's defamed by a third-party comment can seek a court order. But the strange thing about this is the order provides absolutely nothing which can't be already obtained through an order for preliminary discovery, either in the federal court or the state or territory courts. In fact, it's more onerous because the end user disclosure orders have another barrier, namely the likely to risk personal safety refusal discretion. There is no provision at all for takedown, which is what you would think if genuinely this is an anti-trolling bill. There should be a discretion for the courts, not for anybody else, to say, yes, take it down, we've looked at it, but there's no provision for that at all. So this does not add anything to the remedies which are available already to existing people who are defamed by third-party comments. Now, I'm running out of time, so they're the main comments, Angela, that I wanted to make in relation to this.
Thanks, Richard. So I guess from your perspective, a resoundingly negative to the benefits of the bill.
I'm afraid so.
So we'll move on then to Catherine and hear her views in relation to this as well.
Thank you very much. First, I'd like to acknowledge that I'm making this presentation from the land of the Yagara and Turrbal peoples and pay my respects to their elders, past and present. My expertise, as you know, is in hate speech and other types of harmful speech online. And I guess the first point I wanted to say is that speech can harm. In fact, it was refreshing to see the extent to which Senator Stoker conceded that point. It hasn't always been the case that governments have conceded that point. But it's my view that some speech can harm in ways that are analogous to other types of harms that we perceive as more easily regulable. The paradigmatic case, of course, being hate speech, and Australia decided a long time ago in 1989 to implement laws prohibiting hate speech in New South Wales. And so obviously, while free speech is vitally important, it can and should be limited at the point at which it represents a situation in which one person's, I'm sorry, there's a siren outside my office. I don't know if you can hear that. You probably can. I hope there it's passed. At the point at which one person's exercise of their free speech prevents another person from exercising the same human right, of course, governments are asked to step in and regulate, and achieving that balance can be difficult. So as Australia's Attorney General stated when we first introduced federal racial vilification laws, free speech has been balanced against the right of Australians to live free from fear and racial harassment. There are, of course, many types of harmful speech online besides hate speech, such as, for example, threats, cyberstalking, non-consensual pornography, the public release of private documents, and extremism, just to name a few. There are also many types of speech that occur online that are unpleasant, obnoxious, cruel and nasty, but which do not necessarily and ought not necessarily to cross the threshold of actionable harm in the form of a legislative response by government, a threshold which justifies government intervention. There are lots of nasty things that you can't regulate away and you can't legislate away. And in fact, working out the dividing line between what's nasty, obnoxious, horrible and cruel, but you're not going to intervene legislatively, and things that are harmful and therefore warrant a legislative response is a very difficult line to draw, but not impossible. And there's plenty of examples of people doing that well. Firstly, working out where the line is, and secondly, working out if you decide that behaviour has crossed the line, what your legislative response will be. So in response to the bill that we're discussing today, I'm going to talk about 4 particular problems. The first is that most trolling, and I know trolling is in the title but not in the substance of the bill, but certainly in the title and in the government's talking about this bill, they're talking about trolling. Trolling is a very poorly defined activity that captures much activity which is harmful in the sense in which I've just explained, and much activity which is not in the sense in which I've just explained, as in doesn't cross that threshold. It's nasty, it's mean, it's hurtful. People have a visceral emotional response to it, but that doesn't mean it necessarily means it crosses that threshold. So this bill is actually about the type of speech that can be described as defamation, but that's only a very small proportion of what is known as trolling, and therefore there's an argument to be made that this bill just doesn't even really address the problem that and many of the problems that Senator Stoker was talking about. It's been reported in the media that the bill was proposed after Barnaby Joyce's daughter was falsely alleged and unfairly alleged on social media to have engaged in inappropriate behaviour. Joyce was understandably very angry, and in fact, misogynist smearing of women's credibility online is rife. It's rife on social media. There's a lot of work on this. Danielle Citron has reported in Hate Crimes in Cyberspace how this kind of material has been used to prevent women getting jobs, force them out of university studies, and in other ways materially harm their futures. But only a very small proportion of those harms are captured by the concept of defamation. So a great deal of what is captured, what is problematic in terms of online speech, is not going to be regulable under this bill. My second point is that much of the most damaging online harm doesn't come from anonymous accounts. We are led to believe that. It's one of the kind of intuitive things that people believe, but there's a lot of research on this. And the research in this area shows clearly that this is not the case. Many might believe that it's the anonymity of the keyboard that facilitates online harms, but it's actually the case that the majority by far of online harmful speech is proliferated by people who are easily identifiable. Indeed, much of the speech that we would consider harmful occurs in everyday public discourse online and can even be led by politicians and others who seek broad community endorsement from those who share their views. Putting a focus on anonymity, therefore, bypasses the real problems with harmful online speech and places the focus of regulatory intervention in, I would argue, the wrong place. My next point is that is what the real purpose of what the practical effect, I guess, of this legislation might be if it were to be implemented. We do have evidence recently that politicians and some other very powerful people have been using defamation law against their critics, either in the threat of it or in the practice. For example, Peter Dutton has recently had a case against Shane Barzi, a refugee advocate, and we've also recently had Andrew Laming suing journalist Louise Milligan. This legislation is designed to facilitate these kinds of cases, and I'm not here to judge their legal merit, of course. But I do believe, as a scholar who's interested in free speech and the impact of free speech on democracy, that we have, on the one hand, a government that uses free speech rhetoric liberally and claims that people should develop thicker skins, and yet at the same time, some very powerful members of that government who have very public positions suing journalists and activists who criticise them. And I've written in the past about the fact that government figures should have very broad shoulders in this area. Criticism, even vehement and caustic criticism of government members and of parliamentarians, ought to be part and parcel of democratic debate. The point at which the threshold is crossed for public figures ought to be different. So the harms these figures allege, I would argue, don't come close to the material harm suffered by the vulnerable from the vast array of toxic speech online that will remain untouched and unaffected by this bill. And my final point is in response to Senator Stoker's invocation of Section 230 of the Communications Decency Act. I would refer the Minister and any other people who are interested to very credible, well-researched critiques and policy reforms being undertaken in the United States as we speak in respect of Section 230. Section 230 was originally designed to, firstly, Section 230 occurs in the context of the First Amendment. We have nothing resembling that infrastructure in Australia. So the problem that Section 30 sought to address is a different problem from the problem that this bill seeks to address. And the analogy is a very, very weak one. Section 230 was originally designed to give tech companies the ability to clean up offensive and noxious online content without being liable to being sued by people who would say to them, in doing that, you're infringing my First Amendment rights, my free speech rights. How dare you take action against noxious content? It was designed to enable platforms to take action against noxious content and not be liable under the First Amendment, not be liable to First Amendment claims for doing so. The idea was to incentivise, not to penalise, private efforts to filter, block, and address that activity. Of course, in the decades since the introduction of that, the practice has been far from that. Platforms have been completely shielded from responsibility and liability for the content from which they profit enormously. And this has included manifestly harmful content and even encouraging illegal activities. In the words of Marianne Franks, who wrote this wonderful book, The Cult of the Constitution, while Section 230 has played a vital role in the growth and development of the internet's positive potential, it's also incentivised powerful corporations to engage in increasingly risky conduct that inflicts massive harms to privacy, security, and democracy. The immunity of Section 230 has incentivised harmful content in the United States, and there is a very wide consensus in the US that Section 230 needs to be fixed, and there's very widespread, including amongst Republican Party members, there's very widespread acceptance that Section 230 is fundamentally flawed and needs to be changed. And I will finish on a final comment, which is that if we're looking for a useful model for future regulation, we would do well, in my view, to look towards the United Kingdom, which is also debating a very, very capacious online safety bill at the moment, in which they are instituting a statutory duty of care model. So what they're saying is, just as we expect people who build bridges to build those bridges in ways that don't harm the people who drive over those bridges, so should we require people who build and profit from platforms which create profit as a business to operate and construct and regulate and algorithmically drive those platforms in ways that do not harm their users. This is, I think, a very nice idea, and I don't have time to talk about it further, but I wanted to present it as an alternative approach. Thank you.
Thank you, Catherine. And now we'll turn to Henry for his perspective on the bill.
Thank you, Angela. Hi, everybody. I'm Henry. I look after public policy for Snap in APAC, Snap being the company that makes Snapchat. And I'm here to give a platform perspective. So how we approach harmful and abusive content, such as bullying and abuse on Snapchat, our view of what effective regulation looks like in this space. And I'll follow up some of the comments that Catherine made about the UK model and our view of this draft legislation specifically. I should also be clear up front that I'm definitely not an expert in Australian defamation law, and I very much defer to Richard and all of his expertise in that front. It's probably worth me doing a very brief overview of Snapchat, because I imagine that not everybody here today is going to be an avid Snapchat user. So Snapchat as an app is designed differently to traditional broadcast style social media, and is actually designed to be prohibitive for the anonymous abuse of strangers. So the core functionality of the app is private messaging. Snapchat does not have an open newsfeed where people have the ability to publicly broadcast whatever they like. Public areas of Snapchat, so our Discover page for news and entertainment, our Spotlight tab for the community's best snaps, those are curated and pre-moderated, which means that our trust and safety team reviews content here before it can be surfaced widely. Snapchat does not permit public comments on posts, which we've seen can amplify harmful behavior. The app does not facilitate messaging from strangers. By default, you cannot receive a message from somebody who you have not accepted as a friend. And most content on Snapchat is designed to delete by default. That means default settings are such that messages and snaps, which are visual messages, are deleted from our servers once they've been opened, while stories are deleted after 24 hours. So typically content is not sticking around for a long time. Hopefully what comes across from all of that is that Snapchat is a different type of service to online platforms which act as digital town squares designed to facilitate the public broadcast of content. And I think that is relevant to this subject because one of several problems with the anti-trolling bill is that the scope is so broad. This is a bill that is responding to the Voller case, which, as I understand it, focused on public comments made on open public social media pages with hundreds of thousands or millions of subscribers and visible to anybody who visited those pages. Just now, Senator Stoker was stressing the virality of content on such platforms as integral to the rationale for this bill. Yet the way that this bill is worded includes a much wider range of platforms and content within its scope, including, as I understand it, private communications, and doesn't take into consideration responsible measures to prevent anonymous abuse or limit the virality of content. So that's not the only problem with this bill, but it is a significant one. Just back to Snap briefly, over 319 million people around the world use Snapchat every day, and about 5 million of those in Australia. Unfortunately, there are going to be some instances of harmful activity among a user base that large. We can't altogether prevent that, despite all of the design protections that we apply. But what we can do is ensure that such content is not surfaced publicly, as well as providing tools so that people can quickly and easily report concerning content in private spaces of the app, and having teams and processes in place so that we can act on these quickly and effectively. Now I'll turn to the issue of regulation. So at Snap, we're in regular discussions with governments and regulators around the world, including, of course, in Australia, on the development of rules and regulations for online platforms. And I think one question which is helpful to ask when you're thinking about this, the question of regulation is, what kind of requirements and obligations is it reasonable to ask platforms to meet? I think that's important for safety because having clear, achievable objectives makes it simpler for platforms to understand their obligations and to keep people safe. And it makes it simpler also to ensure that platforms are accountable and to enforce against them if they're not meeting their requirements. Conversely, creating unrealistic obligations that can never be met does not help anyone or help make people safer online. And I think if you look at the cornerstones of effective and long-standing online regulation internationally, one of those cornerstones is that it is not reasonable to expect online platforms to know in advance whether all of the content posted there is going to be legal or illegal. You can set very clear guidelines and standards for your users. You can remind them of these regularly. You can make it very easy to report violations. You can enforce against any violations transparently and fairly. You can even limit how widely content can be shared, as we do at Snap, but you can't altogether prevent human users from breaking rules if that's something that they really want to do. Today, we've all been discussing Section 230 of the CDA in the US, which is maybe the most famous piece of online regulation globally. Another similar in some ways and similarly vital and historic piece of tech regulation is Article 14 of the European Union's e-commerce directive, which in a similar fashion is explicit that platforms should not be held liable for individual pieces of content until they become aware of them. And I think that is an important distinction, that responsibilities should change once you become aware of content. And I think that links in some ways to the innocent dissemination defense in Australia that Richard was talking about. I think most people would agree that instinctively that makes sense, that once harmful content or activity is reported or flagged, platforms should be expected to deal with that quickly and effectively. But it's not possible to altogether prevent harmful activity from ever occurring, or reasonable to hold platforms liable for content about which they're unaware. As the Senator mentioned, those pieces of legislation have been vital in enabling the growth of the consumer internet globally. I don't think it's reasonable to hold online platforms liable for content about which they're unaware, as this draft bill attempts to do, just as I actually don't think it's reasonable to hold people or businesses maintaining social media pages on online platforms liable for content, liable for the same. Now, I understand that there is a defense proposed in this bill to that liability, so compliance with a scheme which basically entails handing over the personal information of users to people who feel that they have been insulted or defamed. And this raises a whole host of issues around privacy and protecting user data. At Snap, we work very closely with, and we have to comply with, the rules set by data privacy regulators around the world. We're also committed to data minimization, which means our products and features are designed to collect and store as little user data as possible, which is in line with the priorities of those regulators, but also I think is in line with most people's expectations and their own desire for the privacy and security of their personal information. The IIC, who's the privacy regulator in Australia, have themselves flagged privacy concerns about this complaint scheme and said that more work should be done to evaluate these. So I'm not sure that the government's proposed defense is really much of a defense or is viable for privacy-focused platforms. Now, this is not saying that there's nothing that can be done or that there's no effective regulatory response to trolling and abuse. You know, there is, and a lot of governments and regulators around the world are grappling with these issues, and some of them have found really robust answers. You know, Catherine was talking about the UK, where I'm from, and I was involved in those discussions for a long time, actually, on the government side, and then working for Snap as well. The growing international consensus around online regulation is that the best way to improve responses to illegal and harmful activity, to improve the experiences of users online, to help make online spaces a better place, is to focus on the systems and processes that online platforms have in place to keep users safe. This kind of regulation creates formal mandatory obligations to ensure the safety of users. And it looks at things like, how do platforms prevent harmful activity? Do they enable quick and easy reporting? Do they act on those reports quickly and effectively? Do they have mechanisms in place to work with appropriate authorities like law enforcement? And ideally, that kind of model is enforced by an independent regulator who is then empowered to evaluate compliance with those obligations. That's the kind of model that we're seeing in the EU through the Digital Services Act, in the UK through the Online Safety Bill, and actually here in Australia through the Online Safety Act, which empowers the e-safety commissioner to act as such a body. And that kind of response is internationally recognized as effective. It doesn't have totally unrealistic expectations of platforms that can never be met, but it does ensure that platforms are accountable for user safety, and it has powers to enforce against them if they're not meeting their obligations. It seems strange to me that Australia, where the Online Safety Act is actually establishing such a framework and just passed an act which has a strong focus on bullying and abuse, and which empowers the e-safety commissioner, which, as Senator Stoker was saying, is one of the world's leading expert organizations in this field. It doesn't make sense that the government is then trying to establish this totally separate bill that runs so counter to accepted best practice in this space, and is then billing it or describing it as something that responds to trolling. I think it's pretty widely recognized that because of the costs involved, launching defamation proceedings in court is something that is only available to a small number of people. I think, you know, a lot of the evidence given to the parliamentary inquiry on this subject holds that up as well. So look, I'm conscious that we're running low on time, so I'll bring my comments to an end now.
Thanks, Henry. And can I again encourage people to ask questions, but while we're waiting for some audience questions to come through, I did want to start actually with just a question back to Catherine. You were talking about the possibility of a UK style duty of care. I wondered if you wanted to just comment on some of the things that Henry was saying in terms of the scope of the things that platforms can do, and whether that would fall within your envisaged duty of care here.
So the duty of care idea comes from the UK, and there's a lot of detail. I believe, Henry can tell me if I'm wrong, that originally the idea was to have just one umbrella duty of care, but now they're trying to break it down into different specific areas of duty of care where they can be more precise about what that duty of care might look like. I don't have the legal nous to report on those details. It is clear that platforms are being responsive to globally to calls to behave better, or to take the kinds of actions that Henry talked about in response to the considerable harms that are being facilitated. And it's interesting actually that we're now seeing the open growth of alternative social media companies that launch with the intention of never doing any of that. And of course, Trump's move to launch his own social media company after he was removed from Facebook and Twitter. That's an absolutely perfect example of that. We don't like the regulation you're trying to put in, the private regulation you're trying to put in. We want to be able to behave in any way we can. And that's a democratic problem. That's not a regulatory problem. That's a democracy problem, how we're going to address that. So I do recognise that the platforms are trying hard. I've worked with some of them myself. Their definitions are getting better. Their responsiveness is getting better. Their preparedness to take things down and to remove false accounts and so on it's all getting better. The fundamental problem with it is not that there's not a willingness on the part of good people, good policy people in these platforms to try and help. The fundamental problem, and I don't have an answer to this, is that the business model of the internet is based on clicks, and you get more clicks, the more upset people are. And so the entire business model kind of relies on people behaving, if not badly, then probably not well. And so I'm not sure. There are some people who've proposed, for example, that we break these huge conglomerates down into much smaller entities, and that might make it more possible to respond to that. But I notice Henry's already got his hand up to want to say something about that.
I think the only thing that I would say, Catherine, I think that there's a lot of things that are accurate in what you said. The only thing that I would say is it's important not to think of the internet as one kind of homogenous mass of platforms which are all the same. And I think that's a problem that happens particularly in relation to regulation in this space, where a lot of the legislation is designed for those platforms which aim to serve as those kind of open digital town square style environments. And a lot of platforms like Snap, I think, get unfairly looped into those conversations when actually you can take design protections to make the platform safer upfront. So there is actually an enormous variety in the size, service model, resources, approaches to safety and privacy that platforms put together. And that is why I get concerned when there's bills like this bill, which just have such a wide scope, even though it's actually seems to be developed in response to a very specific issue in relation to comments on large open social media pages. So I think it's just indicative of how sometimes that can be a bit of a risk in this area.
Okay, so obviously we've had largely very negative responses to the bill from our panelists, but I just wanted to raise as a question an issue in support of the bill, I guess, that a reason that has been put forward to support the bill is it does have the potential to promote greater distribution of reliable news stories on, and we'll call it the open social media platforms. So following the Voller decision, if they weren't doing so already, and acknowledging Richard's comment that the Voller decision really did nothing other than apply 100 years of law in relation to determining a publisher, but even or after that decision, media companies would be giving very careful consideration what they put on their open social media pages and when they allow comments to be made on those. So, and I'll direct this question to Richard first. Wouldn't it be a positive outcome by removing the threat of defamation proceedings against media companies for third-party comments, even on limited to just particular sites, that it would encourage media companies to make available more reliable news content on those social media services?
Well, firstly, of course, it doesn't change anything about liability for primary publication of media publishers on their Facebook pages or internet sites. It's only liability for third-party users. And Senator Stoker doesn't mention anything about innocent dissemination, let alone it's broken, so it needs to be fixed. Secondly, I understand Facebook has, since the Voller case, has introduced different systems to filter and control and offer moderating facilities to better control comments, either leave them out or deal with them in a way that was better than before. And thirdly, I think what Catherine said in relation to providing an immunity is pretty chilling, that immunity provides abuse of power, and in America it's encouraged noxious, if not illegal, activity which cannot be controlled because these people are immune, and that's not an inspiration for anti-trolling. And so in Voller, the post was, the Royal Commission portrays Dylan Voller as a hero. I think that's disgraceful. What do you think? That's the post that generated all the trolls that never got taken down. And so if there's a complete immunity from that, in my view, it's not going to assist, it's not going to encourage more accurate news, it's going to go the other way. That's my view about that.
Catherine, did you have anything you wanted to add there?
Yes. The thing about the moderation and the extra efforts that Facebook, for example, has introduced, they're interesting. So Facebook says, I don't know if it says this very openly, but it has something like 15,000 moderators globally. They're each given a policy manual that's very, very thick. They're given training, of course, but in the end, you've got obviously a lot of the moderation is now algorithmically driven, but the difficult cases and the line ball cases end up in front of human beings. Firstly, that's very, very hard work. There's plenty of information that the people who do that moderating work suffer from significant psychological effects from some of the material that they're exposed to. Secondly, it's very hard to get consistency globally when you've got 15,000 people using a very, very thick policy manual. So again, I make those comments again just to suggest that the platforms are trying. I absolutely take your points on board, Henry. We need to differentiate between different platforms. But these big open source platforms, they're trying, but there are structural impediments to their ability to do it better. So I think I've already made it clear that I think removing liability completely is a bad idea. But I also think that there are problems with relying on the platforms to do it well enough to get a result as well.
Okay, thank you, Catherine. Henry, did you want to add anything to that? Conscious of time.
Sure.
Well.
I mean, the only thing I would say is, I guess that there's two elements here, right? There's how the publishers are approaching, the news publishers are approaching this issue, and then there's how you're policing or moderating human user-generated content in reaction to that. I think, like, presumably, on Snapchat, certainly publishers agree to abide by very strict content standards. A higher standard then applies to an ordinary user, but presumably news organizations in Australia are also a subject to journalistic standards regardless, right? And there's an existing regulatory framework for that. And in regard to how users interact online or in relation to those posts, I think, I've set out what I think is the best way of moderating speech and content, which is just setting very clear rules and ensuring that platforms are enforcing against those once it's reported to them.
Okay, thank you. So we only have a couple of minutes left, so we'll wrap it up there. And I hope you all enjoyed the debate today as much as I did. And so I'd like to thank again our panelists for providing their insights on what is a short bill that raises many, many issues. You can expect many more interesting forums like this from the Australian chapter over the following year, and hopefully most of those events will be in person, and we'll look forward to meeting you in person at those events. And I wanted to end with reminding you all about the options for membership of the Australian chapter of the IIC. We've recently introduced a new membership option that is open to expert advisory firms and representatives supporting Australia's digital ecosystem. So if you want to hear more or learn more about joining the Australian chapter, please visit the IIC's website. And thank you very much for participating today.
Thank you.